Israel has legitimate security concerns, but also the obligation to comply with international law. Similarly, the Palestinian people has the right to self-determination with the aim of living in peace, and Palestine has the obligation to respect international law, and fair and lasting solution can only be achieved on the basis of the rules of international law. A good understanding of the content of the obligations under international law is therefore a precondition for negotiating a solution that reflects the legitimate interests of both parties. Thus, it's therefore essential to better understand the legal questions relating to measures taken within the framework of the prolonged occupation of Palestinian territory. The opportunity for the court to provide an impartial response based on international law to the questions posed by the General Assembly and thereby provide a basis for a negotiated solution, therefore remains essential. My oral presentation will focus on the specific issues linked to the prolonged occupation under the angle of international humanitarian law and human rights law. Moreover, I'll refer to our written submission of 17 July 2023 and to the developments contained therein. The law of the occupier and the legality of occupation are two distinct questions. The law of occupation applies independently of the question of the legality of occupation. Occupation is the situation that is governed by international humanitarian and human rights law, whereas the legality of it is governed by the UN Charter. The potentially illegal character of an occupation must not call into question the fundamental separation between jus ad bellum and jus in bello. The right of occupation continues to apply in Palestinian territory, irrespective of the question of the legality of the occupation. As such, the prolonged character of an occupation has no incidence on its conformity with jus in bello. No provision of humanitarian law prohibits prolonged occupation. What's more, prolonged occupation remains governed by humanitarian law, supplemented by human rights law, irrespective of a de facto possible annexation. Nevertheless, occupation is understood as a temporary situation. Occupation that is prolonged may lead to a tension between, on the one hand, the obligation for the occupier to maintain the status quo ante, on the other hand, to ensure the well-being of the occupied population. It is this tension and its legal consequences that I'd like to deepen within the framework of this oral submission. To do this, I'll begin by generally addressing the prolonged occupation and the challenges it poses from the standpoint of humanitarian and human rights law. Next, I'll analyze three concrete areas illustrating this tension: the need to interpret and apply contemporary international law in an evolving and systemic manner to ensure protection and well-being of the population. The concrete areas addressed are firstly the legislative administrative competences of the territory, secondly access to items that are indispensable to the survival of the population and protecting dignified life, and lastly, use of force in occupied territory. Allow me, first of all, to address the legal challenges posed by prolonged occupation. The rules of the law of occupation were not developed to regulate situation of occupations lasting several decades. They're based on four fundamental principles that underscore the necessary temporary nature of occupation and to establish a balance between military and humanitarian necessity. Firstly, the occupier doesn't acquire sovereignty over the territory he occupies. Unilateral measures calling into question the territorial status quo are therefore never admissible. A modification of the status of occupied territories can only be envisaged within the framework of a negotiated solution. Secondly, the occupier must maintain the status quo ante and not take measures that might lead to permanent changes, in particular from the social, economic and demographic standpoint. Thirdly, the occupier must maintain security and public order in the occupied territory and administer it in order to ensure the protection and well-being of protected persons. Fourthly, the occupier must not exercise his authority for the purposes of serving his own interests, that of his territory or his population. Within the framework of a prolonged occupation, tensions might indeed appear between these four principles. For example, the well-being of the civilian population might necessitate changes to the status quo. In this context, there's a need to distinguish clearly unlawful situations that undermine the status quo, such as, for example, settlements, from those where the status quo would in fact be maintained to the detriment of the population of the occupied territory. In this case of a prolonged occupation, it is vital that the maintenance of the status quo should not be understood as a freeze on the situation, but as signifying that the populations of occupied territories must continue to be able to live a normal as life as possible in dignity. Occupied territories must not remain frozen in time, but be able to move with their time. To address the legal tensions and challenges specific to a prolonged occupation, it's important to recall the function and the purpose of humanitarian law are to protect and ensure the well-being of the population and not to justify intrusive measures in the interest of the occupying power. The obligation of the occupying power to ensure the well-being of the occupied population calls for an interpretation in favor of the higher interests of the population living under occupation. In order to resolve the tension between the aforementioned principles and better determine the legality of measures taken by the occupier during a prolonged occupation, I suggest three criteria derived from a combined interpretation of humanitarian and human rights law. Firstly, the adoption of specific measures going a priori against the obligation of maintaining the status quo to serve the interests of the occupier is not admissible except for overriding security reasons and as long as the well-being of the population is not affected in a disproportionate manner over the long term included. Secondly, specific measures running counter to the obligation to maintain the status quo can be adopted if they benefit the population of the occupied territory, consistent with human dignity, and take account of the wishes of the population in the occupied territory and its historical and cultural specificities. Lastly, thirdly, the adoption of such measures is statutory when these measures amount to parallel obligations of humanitarian and human rights law. If humanitarian law was specifically designed to govern situations of armed conflict, it remains that human rights remain fully applicable in situation of occupation. The Fourth Geneva Convention compels the occupying power to assume active responsibility for the well-being of the population under its control. This obligation to protect the population under occupation and to promote its well-being is concretized in the obligation to respect, to protect and to fulfill the human rights of the occupied population. The characterization under humanitarian law of lex specialis must therefore not be construed as meaning that this law overrides human rights. In principle, there's no direct contradiction between the obligations arising out of humanitarian law and human rights law. On the contrary, humanitarian and human rights law are mutually reinforcing. Thus, Article 27 of the Fourth Geneva Convention requires that the fundamental rights of protected persons be respected in all circumstances. It proclaims the respect of the human person and the inalienable right of its fundamental rights. In the event of prolonged occupation, the relevance of human rights is all the more significant. The logic of humanitarian law is aimed at immediately ensuring the essential minimum needs of the population. This must be supplemented by the need of ensuring over the long term a dignified life. Thus, the balance between humanitarian and human rights law fluctuate with the prolonged character of an occupation. The longer the occupation is prolonged, the more the respect for and guarantee of human rights are important. To close this part, I'd like to stress that all actors exercising de facto control are also bearers of obligations at Israel's side. The practice of UN organs recognizes that, at minimum, an armed non-state actor exercising the governmental type functions or controls, in fact, a territorial population must uphold and protect the human rights of the inhabitants. Palestine, having notably ratified Covenants 1 and 2 of the UN relating to human rights and the UN Convention against Torture, has the positive obligation to take all measures in its power and compatible with international law to assure to persons living in these parts of its territory the rights guaranteed by the Convention. Israel and Palestine are under obligation to cooperate and support one another and not to weaken one another in their efforts to ensure the well-being of the population. Victims must also be able to seek reparation for violations or abuse of their rights, whoever the actor at the origin of their grievance, in order to ensure effective respect of human rights. These various actors must cooperate by taking into account that the scale of their obligation will vary notably of the control they exercise and the resources available to them. I come now to the concrete areas, starting with that of legislative and administrative competences of the territory. By virtue of the principle of maintaining the status quo, the occupier cannot take measures bringing about permanent changes, in particular the social, economic and demographic standpoint. The occupier must restore and ensure, as far as possible, public order and safety while respecting, unless absolutely prevented, the laws in force in the country. However, by virtue of Article 64, paragraph 2 of the Fourth Geneva Convention, we can deduce that the occupier might introduce new laws if these are indispensable to ensure A, the security of the occupier, B, order of public life, and thirdly, respect for humanitarian law. Though human rights are not in the exceptions of maintaining local law, an updated reading of humanitarian law requires that their respect be guaranteed. Thus, in the case of prolonged occupation, the obligation to ensure public order and safety implies that the occupier administers the territory in such a way as to ensure protection and well-being of protected persons, not only respect and protect, but also provide them with a right to a dignified life. This, of course, means that he has to move away from the status quo. Mr. President, members of the court, the adoption of measures such as planning, zoning, contradicts the previously mentioned criteria. This regime contributes to put in place a coercive environment, aggravating the risk of forced transfer. Aside from the fact that this regime calls into question the territorial and demographic status quo by promoting Israeli settlements, it cannot be justified under security requirements because it excessively affects the well-being of the population and is discriminatory. In the event of prolonged occupation, the occupier is required, on the contrary, to encourage planning and development of the occupied territory as a priority through local authorities and institutions in favor of the local population. This requires, Mr. President, members of the court, a cooperation with local institutions, support and a strengthening of the latter and not their erosion. I will now turn to the second concrete area, that's to say access to vital goods for the survival of the population and protecting a dignified life. Humanitarian requires that the occupier supplies the population with essentials for its survival. The obligation to restore order and public life must be interpreted broadly and designates the various aspects of the life of the population. The occupier is therefore entitled to make changes going a priori against the status quo as long as they're necessary to improving local life. As indicated above, the conditions of existence of the population under occupation are also governed by human rights, which notably, in a context of prolonged occupation, support and reinforce humanitarian law. The occupier must immediately ensure minimum enjoyment of economic, social and cultural rights and refrain from adopting measures that would limit their exercise. Next, with the prolongation of occupation, the obligation to gradual achievement comes into play. It requires the occupier fully assumes the exercise of these rights in time. Furthermore, by virtue of the right to life, the occupier has the obligation to generate conditions of existence in accordance with human dignity for persons living under his jurisdiction. In the face of prolonged occupation, the economic and social development of the territory may require long-term changes which are opposed to maintaining the status quo. This, of course, creates obligations for Israel as occupying power as well as for Palestinian actors. Mr. President, members of the court, these regressive measures and the use of resources on Palestinian and on occupied Palestinian territory, regressive measures and the use of resources of the occupied Palestinian territory for the needs of the occupier clearly run counter to the previously mentioned criteria. They require modifications of the status quo for the interests of the occupier to the detriment of the Palestinian population. Furthermore, the absence of a gradual realization of human rights is an issue of concern. Lastly, third specific area illustrated in the context of prolonged occupation, the tension between the right of the occupier to guarantee his security, the obligation to ensure the well-being of the population by using the example of the use of force in operations to maintain order. Under Article 43 of the Hague Regulations, the occupier may use force to restore and ensure, as far as possible, public order and safety. However, such a use of force should not lead be a matter for the conduct of hostilities. Article 43 is but a referral to rules of maintaining order that form part of human rights and the right to life. Maintaining order rests on three principles: necessity, proportionality, and precaution. By way of the principle of necessity, the use of lethal force can only be used in last resort and must pursue an objective goals such as self-defense or to defend a third party in the event of imminent threat to life. This imminence criteria is strict and cannot authorize use of force preventively. Furthermore, the use of force must always be individualized. A crowd of demonstrators cannot be considered as such as a threat to life. Furthermore, a differentiated use of force must be used if possible. This requires supplying appropriate equipment and weapons for maintaining order, including water cannons, batons, and rubber bullets. By virtue of the principle of proportionality, the degree of force used must be strictly proportionate to the gravity of the offence and the legitimate goal to be reached. Incidental losses are generally not tolerated, and the life of persons who disrupt order must be taken into consideration when weighing up the interest. By virtue of the precautionary principle, law and order operations must be planned with the goal of avoiding the use of lethal force. All this is removed from a logic specific to the conduct of hostility. In the context of occupation that is prolonged, maintenance of order is applied by default. Hybrid situations of civilian and hostile violence must be far rarer than the context of a nascent occupation. Weapons and equipment made available to occupying or security forces must be similar to those which are used by states in peacetime. The use of combat weapons and the use of snipers is even more inappropriate during long-term occupation. The militarization of maintaining order operations must be avoided ex ante when a legitimate legislative and administrative framework must be put in place to regulate the use of force, and the training of Israeli forces must be consistent with international maintenance of order. Ex post, any use of lethal force must be the subject of an actual investigation to ensure accountability, and in the case of proven violations of human rights, there is a requirement to bring those responsible to justice. Israel, as an occupying power, must protect the civilian Palestinian population in the West Bank. The violence exercised by individuals such as settlers towards the population of the occupied Palestinian territory must also be investigated and, where appropriate, subject to criminal proceedings. The positive obligation to protect the population from third parties is an essential component of the right to life. In conclusion, prolonged occupation may a priori give rise to tensions between maintaining the status quo, security of the occupier, and the well-being of the population. These tensions are resolved by humanitarian law supplemented by human rights law. The longer the occupation, the more respect and guarantee of human rights are important. The joint application of these two legal regimes strengthens the protection of populations living under occupation and may impose specific measures that run counter to the obligation to maintain the status quo. Thus, the development of the territory requires the adoption of positive measures in favor of the population of the occupied territory. Similarly, the well-being of the population requires transformations aimed at improving its conditions of life. Lastly, in the presence of a prolonged occupation, the use of force is presumed to form part of law and order. All parties must prevent violence and the resurgence of hostility in order to guarantee a life as dignified and as normal as possible to the population. In this spirit, Israel and Palestine must cooperate and support one another mutually and not weaken one another or erode the authority of the other party. Mr. President, members of the court, this brings to an end the written submission of Switzerland. Thank you for your attention.
Je remercie la délégation de la Suisse pour son
I'd like to thank Switzerland for their exposé.
Public to address the court and call His Excellency Mr. Ammar Al-Hassan to the podium.
Mr. President, distinguished members of the esteemed court, it is an honor and privilege to address the esteemed court today on behalf of the Syrian Arab Republic at a very sensitive time, while the Palestinian people find themselves with no real protection. In this oral statement, I will present my country's position regarding the questions related to this case in accordance with what was stipulated in the relevant General Assembly resolution. Out of respect for the time allotted to me by the esteemed court, I will get straight into presenting my country's legal position. Mr. President, distinguished members of this honorable court, the theory of occupation in principle contradicts all the values, ethics, laws, and charters that humanity has established throughout its long history. In order to preserve human dignity and sanctity, to maintain international peace and security, and to save the world from the scourges and sufferings of wars. In fact, the crime of occupation has been and continues to be the most serious and heinous crime in the history of mankind, taking into consideration the occupation's flagrant violation of the Charter of the United Nations, the provisions of international law, international human rights law, and international humanitarian law, and all international charters and customary rules. In fact, occupation acts primarily on the basis of usurping land by force, which is essentially prohibited under international law and the provisions of the Charter. It also acts on the basis of suppressing the will of the people, seeking to degrade their dignity and deprive them of their basic rights. Today, the practices of Israel, the occupying power, are definitely the clearest reflection, unfortunately, of the failure of the international community to prevent heinous crime of occupation and to ensure the implementation of the relevant resolutions of Security Council, General Assembly, and the Human Rights Council. The Syrian Arab Republic stresses the need to hold Israel accountable for its grave and continuing violations of the provisions of international law, the Charter of the United Nations and its relevant resolutions, and the provisions of international humanitarian law, including provisions in Section 3 of the Fourth Geneva Convention of 1949, Article 47, and what follows. Mr. President, distinguished members of the Court, we are here today to make sure that they, the occupiers, do not get away with impunity. The first question before the distinguished Court today relates to one of the most important and noble human rights, which is the eternal and fundamental right to self-determination. The right to self-determination is a fundamental human right that is enshrined, among other international instruments and conventions, in Article 1, Paragraph 2 of the Charter of the United Nations, providing that each state shall, and I quote, refrain from any forced action depriving peoples of their right to self-determination, freedom, and independence, end of quote. And that each state shall, again I quote, encourage through joint and unilateral action the realization of the principle of self-determination of peoples, end of quote. This right is also reiterated and affirmed in common Article 1 between the Covenant on Economic, Social and Cultural Rights and the International Covenant on Civil and Political Rights, which obliges states that are parties to these covenants to promote the realization and respect of this right in accordance with the provisions of the Charter of the United Nations. Israel violates this right through, for example, the establishment and continued expansion of illegal settlements in the occupied Palestinian territories, including Jerusalem. We note, in particular, the discriminatory Israeli legislation of 2018, or what is so-called the Basic Law, Israel as the nation-state of Jewish people, which recognizes the right to self-determination exclusively for the Jewish people, denying the right of the Palestinian people to self-determination on their land and in their homeland. I shall now turn to talk about the legal consequences. Israel must be held accountable for its violations of international law and United Nations resolutions. Israel must put an immediate end to the violation of its international obligations by halting all actions and measures that prevent and/or impede the exercise of the Palestinian people's right to self-determination, including putting an immediate end of the occupation in all its forms. For third states, since the right to self-determination is an erga omnes argument and obligation on all subjects of international law, all states must respect it and seek to achieve it. It is also the responsibility of all states, consistent with the respect for the United Nations Charter and international law, to immediately put an end to the obstruction of the Palestinian people's exercise of their right to self-determination. The United Nations, in particular the General Assembly and the Security Council, should consider the additional procedures and binding international legitimacy tools stipulated in the Charter that are required to put an immediate end to any obstruction preventing the Palestinian people from obtaining their right to self-determination, and to take the necessary measures in order to ensure the implementation of its relevant resolutions without any further delay. With your permission, Mr. President, I shall delve into the part of the question regarding prolonged occupation, settlement, and annexation, along with changing the demographic composition. The illegal Israeli settlements and the system associated with them are based actually on a dual process. On one hand, the forced displacement of Palestinians and the confiscation of their lands, and on the other hand, the transfer of Israeli settlers and the construction and expansion of settlements on confiscated lands. International humanitarian law prohibits the forced displacement of the occupied people and the transfer of citizens of the occupying power to the occupied territories, as confirmed by Article 49 of the Fourth Geneva Convention that provides for the protection of civilians in the time of war. Thus, forced displacement and transfer of citizens by the occupying power constitute grave violations under Article 147 of the aforementioned Convention. Indeed, the actual annexation of parts of the occupied Palestinian land is embodied through a continuous gradual process involving the implementation of many measures and actions that include, among others, settlements' size, infrastructure, and location, which indicate the purpose to make them sustainable. Israeli government plans and directives that allowed the establishment and expansion of settlements. The legislation that enacted a dual legal system in the occupied territories in favor of the settlers at the expense of the occupied people, including the Basic Law of 2018, aka Israel as the nation state of the Jewish people. Another example, public statements of Israeli officials demonstrate to the fact that the settlement and the system associated with them constitute a deliberate policy of obtaining a permanent presence for the annexation of the territories and confirm that the actual annexation had already taken place. The guidelines and coalition agreements of the new Israeli occupation authorities sworn in on the 29th of December 2022, in which they explicitly declare that the Jewish people have an exclusive and indisputable right to all areas of Israel and undertake to strengthen and develop settlements throughout what they called the land of Israel in the Galilee, the Negev, the West Bank, and in the occupied Syrian Golan, despite the confirmation by the United Nations Security Council Resolution 497 of 1981 that provides, and I quote, "The Israeli decision to impose its laws, jurisdiction, and administration in the occupied Syrian Golan Heights is null and void and without international legal effect." End of quote. Mr. President, distinguished members of the Court, in 1980, the Israeli Knesset adopted the Basic Law on Jerusalem, which states that Jerusalem, whole and united, is the capital of Israel, effectively annexing the city in flagrant violation of international law and of the city's own international status. In response, the United Nations Security Council adopted Resolution number 478, which declared that, again I quote, "all legislative and administrative measures and actions taken by Israel, the occupying power, which have altered or purport to alter the character and status of the holy city of Jerusalem, and in particular the recent Basic Law on Jerusalem, are null and void and must be rescinded forthwith." Mr. President, since then, the Israeli occupation authorities have worked to consolidate further annexation instead of reversing it. I shall now talk about the legal consequences. Israel is obliged to immediately stop all its violations of its legal obligations in Jerusalem and all other occupied Palestinian territories. The cessation of such violations entails, inter alia, the dismantling of illegal structures, including settlements and the apartheid wall, the cancellation or the activation of all legislative and regulatory acts adopted by Israel with the aim of building illegal settlements and normalizing said system. Also, Israel is obliged to make reparation for the damage caused to individuals concerned through restitution and compensation. Regarding the legal consequences for third states, the United Nations General Assembly, in its resolution 77/25, called on all states, inter alia, first, not to recognize any alterations to the pre-1967 borders and to ensure that agreements with Israel do not imply recognition of Israeli sovereignty over the territories occupied by Israel in 1967. Second, not to provide aid or assistance to illegal settlement activities, specifically with settlements in the occupied Arab territories of Palestine and the Golan, in line with Security Council Resolution 465 of 1980. For the United Nations, the international organization, in particular the General Assembly and the Security Council, should consider the additional measures and binding international legitimacy tools stipulated in the Charter that are required to immediately end the illegal occupation and take the necessary measures to ensure the implementation of its relevant resolutions without any further delay. Your Honours, just as a reminder, today we are talking about a huge record of UN resolutions that Israel keeps violating. Actually, when it comes to the Arab-Israeli conflict, we are talking about 180 resolutions of the General Assembly and 227 resolutions of the Security Council. Mr. President, allow me now to move on to the part of the question regarding discriminatory legislations and measures. Since its inception, Israel has adopted various discriminatory legislations aimed to ensuring its control over the maximum geography with the minimum possible number of Palestinians. The United Nations Human Rights Council has described the Israeli discriminatory measures as, and I quote, a combination of movement restrictions consisting of the wall, checkpoints, a permit system that affects only the Palestinian population, and the application of a two-tier legal system that facilitated the establishment and consolidation of settlements and other violations and forms of institutional discrimination. End of quote. The United Nations General Assembly has always, and for many years, condemned in a large number of resolutions the discriminatory policies and practices of Israel, the occupying power, against the Palestinians as well as the Syrians in the occupied Syrian Arab Golan. These policies and practices include, according to these resolutions, killing and injuring civilians, arbitrary arrest and detention, in addition to forced displacement of civilians, transfer of settlers to the occupied Palestinian and Syrian territories, destruction and confiscation of civilian properties, and demolishing homes. Your Honors, in the devastated Gaza Strip, long before the 7th of October 2023, Israel practices racial discrimination towards the Palestinian population in the form of its ongoing blockade. The discriminatory nature of the blockade actually imposed on the Gaza Strip was recognized by the United Nations Committee on the Elimination of Racial Discrimination. This blockade was found to violate the Convention on the Elimination of Racial Discrimination. The actions of Israel are part of a large-scale, repressive, organized and systematic regime. Such actions have been identified as apartheid after thorough factual and legal examination by the UN Special Procedures and by various international organizations. Apartheid is most manifested in the occupied Palestinian territories, including Jerusalem, where illegally located settlers benefit from far-reaching privileges at the expense of the basic rights of the Palestinian people. For legal consequences, Israel is obliged to immediately repeal all legislations aimed at or leading to the maintenance and perpetuation of apartheid and racial discrimination against the Palestinian people. This includes the termination of its settlement activities, the cessation of all discriminatory policies and practices, along with due compensation to all those affected by these policies and practices, including Palestinian refugees. For third states, they must not recognize this illegal situation and must not provide any help or assistance in any way that may sustain and maintain this situation. For the United Nations, especially the General Assembly and the Security Council, the international organization should consider the additional measures required to end the apartheid system established by Israel and should take the necessary measures to ensure the implementation of its relevant resolutions without further delay. After this review, allow me, Mr. President, to present my country's legal position on the second question presented before the distinguished court in accordance with the relevant General Assembly resolution. It's about illegal status of occupation. The acts and practices of occupying powers are strictly regulated by international law and international humanitarian law. Article 49, paragraph 6 of the Fourth Geneva Convention stipulates that, and I quote, "The occupying power shall not deport or transfer parts of its civilian population to the territories it occupies." End of quote. While the occupying power is obliged under international law to administer the territory for the benefit of the people under its occupation, Israel administers the territory only for the benefit of its settlers and even to ensure the sustainability of the illegal occupation of others' land. While annexations or claims of sovereignty over territories under the interim administrative authorities of the occupying power are strictly prohibited, Israel has sought to exercise fait accompli sovereignty over Jerusalem and the occupied Arab territories. Mr. President, members, distinguished members of this honorable court, we believe in the first place that the Israeli occupation in and of itself should be considered absolutely illegal, and that we should not be satisfied with only and merely describing its practices and policies. Allow me now to move to the legal consequences. The legal consequences constitute Israeli commitment to an immediate and unconditional end to its occupation of the Arab territories in Palestine and the rest of the occupied Arab territories, including the Syrian Arab Golan, in addition to providing compensation to all those affected. For third states, it is imperative to commit to support all efforts exerted to end the illegal occupation without delay, and to refrain from any actions that contribute to maintaining the illegal situation. For the United Nations, in particular the General Assembly and the Security Council, it should consider the additional measures and binding international legitimacy tools stipulated in the Charter that are required to ensure the implementation of the relevant resolutions without any further delay, including the immediate and unconditional end to the Israeli occupation of the occupied Arab territories in Palestine and the Syrian Golan. The Honourable Judges, the Syrian Arab Republic affirms the principle that states shall not obtain legal rights from unilateral acts that do not comply with international law. Syria also re-emphasizes the temporary nature of the occupation, and that even if it is a fait accompli, this does not and will not give the occupying power the right to acquire sovereignty over the occupied territories, no matter how long this brutal occupation lasts. Syria reiterates that the stability of the Middle East and the credibility of the United Nations system, including the esteemed court, require taking measures to ensure the implementation of all relevant international resolutions to end the Israeli occupation of all occupied Arab territories in accordance with the relevant United Nations resolutions. Mr. President, esteemed members of the Court today, in this case, does not create new rights, but rather reveals rights that are violated by Israel every day since 1948. Israel is not only committing the horrendous act that we have just mentioned, but we are currently witnessing Israel committing genocide in the occupied Gaza Strip, attacking Syria, attacking Lebanon, and committing war crimes and crimes against humanity. In fact, one of the reasons for Israel's consideration of itself as being above the law is that it has been carrying out illegal occupation and committing crimes for 75 years without facing accountability or any sort of consequences. Today, it has become imperative for all states to convince or to show Israel, the occupying power, by all possible legal means that it does not have a green light to annex more occupied territories, expel their indigenous people, and build more illegal settlements. Most importantly, convincing and showing Israel that there will be no peace, no security or stability for all and equal without ending the occupation and establishing a viable and sustainable Palestinian state that possesses full competence and authorities like all member states of international community. The continuance of these violations means more Israeli escalations vis-à-vis the Palestinian people exercising their legitimate right to resist the occupation. Many decades have passed, and the suffering of the Palestinian, Syrian, and Lebanese peoples under the Israeli occupation continues, mainly due to the absence of a decisive and credible political will that is keen to implement the provisions of international law. Your Honours, today, and for all these reasons, and for the sake of genuine peace and unshakable justice, we look forward to the role of jurists who took it upon themselves to equally uphold the provisions of the law in order to contribute to achieving peace and justice to those people suffering under the most violent, most tyrannous, and most oppressive form of occupation in the history of humanity. Thank you, Mr. President. Thank you, distinguished members of the Court.
I thank the delegation of the Syrian Arab Republic for its presentation. J'invite la délégation.
I invite the next participating delegation, that's Tunisia, to address the court and call Professor Slim Lagmani to the podium. You have the floor, sir.
Monsieur le Président,
Mr. President, distinguished members of the court, it is an honour for me to appear before your esteemed court to set out Tunisia's point of view on the request for the advisory opinion before you. This is a request for an opinion which deals with the oldest and most unbearable injustice, namely that of the Palestinian people. In December 2022, Tunisia voted in favour of Resolution 77247 because it was then and remains now convinced that an impartial and lucid legal opinion given in response to the questions posed by the General Assembly is necessary not only for the General Assembly and the United Nations, but even more so for the international community as a whole. Regarding questions relative to the jurisdiction and discretion, we are of the opinion that those arguments which led the court in its advisory opinion on the legal consequences of the building of a wall in occupied Palestinian territory to conclude, I quote you, not only has the court jurisdiction to give an opinion on the question posed to it by the General Assembly, but there is no compelling reason for the court to use its discretion to not do so. End of quotation. We are of the opinion that these arguments are valid for the instant request for opinion. There is, however, a specific argument in favour of the eminently legal character of the questions put in the instant request, and they're worthy of development. The reference by the General Assembly successively to occupation, to colonisation, annexation, shows that it is the law which is at the centre of the questions asked. Indeed, given the policies and practices of Israel in the OPT, we need to respond to the next question. Can we still speak only of an occupation, understood as placing a territory under the authority of an enemy army? Don't you think that really today this is a euphemism? Hasn't Israel gone far further than just merely annexing de jure or de facto Palestinian territories by adopting laws and measures, discriminatory laws and measures, besieging Gaza since 2007, and conducting since 7 October 2023 a war of annihilation? Going further, in what legal category can Israel's illegal presence in Palestinian territory be placed? And like what some have claimed, the advisory opinion by the court answering this question would in no fashion be an obstacle to a negotiated political settlement of the Israeli-Palestinian conflict. Quite to the contrary, it's very useful to negotiations that negotiators be informed by an impartial third party on what they are legally entitled to demand and what they can or must renounce. But perhaps first we should look at what violations are in issue, and then we'll see subsequently what their legal consequences are. Mr. President, distinguished members of the Court, you have all the necessary elements establishing the continuing violation by violation of the right of the Palestinian people to self-determination, of the prohibition of aggression, the acquisition of territories by force, the serious and persistent violations of the human rights of Palestinians, and the intransgressible rules, that's your own words, of international humanitarian law. Amongst these elements, we shall refer specifically to those established by the decisions of the Security Council, which cannot be accused of bias against Israel, and by the Court, whose independence, in your opinion of 9 July 2004, is beyond doubt. Those principles and rules breached figure in the non-existent list of peremptory norms of general international law annexed by the International Law Commission to their draft conclusions relative to the determination and legal consequences of Just Kogan's norms. The Court, for its part, has characterized certain of the norms breached as Just Kogan's rules, as, for example, the prohibition for the interdiction of prohibition of torture, crimes constituting serious breaches of the Geneva Conventions of 1949, and others have been qualified as erga omnes rights or obligations, of cardinal principles, of intransgressible principles, of principles, essential principles of contemporary international law, or indeed rules dictated by elementary considerations, of humanity. Now, in the time frame that we have for this oral presentation, we can't look at all of these violations. It will suffice to show that the occupation of Palestinian territories, considered as a whole and in terms of duration, has as a final aim the negation of the Palestinian people's right to self-determination and the acquisition of its territory by force, and to attain this end, Israel has not hesitated to choose the most heinous of all means, namely the genocide of the Palestinian people. Let's look at the negation of the right of the Palestinian people to self-determination. At the end of the First World War, Palestine was placed under British Mandate A. Under Article 22, Paragraph 4 of the Covenant of the League of Nations, this mandate concerned, I quote, certain communities formerly belonging to the Ottoman Empire, which was the case of Palestine. These communities, as the article continues, have attained a level of development such that their existence as independent nations may be provisionally recognized. The League of Nations considered thus that Palestine was a nation, and that the mandate, when it expired, should have led to the definitive independence of Palestine, and this over the entire territory under the mandate. Now, throughout the mandate, the UK implemented the Balfour Declaration, part of the British mandate over Palestine. The declaration provided not for the creation of a Jewish state, but, I quote, for the establishment in Palestine of a national home for the Jews. This process led to Resolution 181, second session of the General Assembly of 29 November 1947, which recommended placing the city of Jerusalem under a special international regime, as well as a partition plan granting the Jewish state 56.47% of the mandatory Palestine Territory. This recommendation, which ignored the raison d'etre of the mandate, which was to lead Palestine forwards towards a definitive independence over the entirety of the mandated territory, had to be accepted by both parties to have legal effect. Now, the Jewish party accepted it, but the Palestinians and the Arab states of the region refused. The Jewish party, however, rushed to proclaim its state, and subsequently there was the 1948-1949 war, which led to a reduction of 23% of the space conceded to the Palestinian state by Resolution 1812, and to the exile of 750,000 Palestinians. Now, the effect of this war and the power balance which resulted were at first a step backward. The recognition of the existence of a Palestinian people and of its right to self-determination by the political organs of the United Nations was slow to come. With your permission. To start with, the Palestinians were considered as refugees, and we had to wait until 10 December 1969 for the General Assembly to recognise the inalienable rights of the people of Palestine. On 30 November 1970, the General Assembly will condemn governments, I quote, which refuse the right of self-determination to peoples to whom this right has been recognised, inter alia, the peoples of South Africa and of Palestine, and they will recognise the legitimacy of the struggle undertaken by those peoples subject to a foreign and colonial domination by all means at their disposal, and to obtain their recognised right to self-determination. End of quotation. The solemn recognition of the Palestinian people will come on 22 November 1974, where the General Assembly will assert the inalienable rights of the Palestinian people in Palestine, including A, the right to self-determination without external interference, and B, the right to independence and to sovereignty. The Security Council will be even slower to use the expression Palestinian people in its resolutions. It's in its Resolution 605 of 22 December 1987 that the Security Council will assert, as far as we know for the first time, the existence of a Palestinian people, where they say they deeply regret the policies and practices of Israel, the occupying power, which breaches the human rights of the Palestinian people in occupied territories. In Resolution 672 of 12 October 1990, the Security Council will recognise the legitimate political rights of the Palestinian people. The Court will draw the consequences of this in its advisory opinion of 9 July 2004. The existence of a Palestinian people is no longer an issue. I quote you there. The recognition of the existence of a people carries with it the recognition of its right to the equality of rights, the creation of an independent and sovereign state, to the liberation and integrity of its territory. Now, clearly, the Palestinian people has been deprived by force from the enjoyment of all of those rights. That's what the Court will conclude on 9 July 2004. I quote you. The obligation erga omnes to respect the right of the Palestinian people to self-determination is breached by Israel. But it wasn't only its right to self-determination that the Palestinian people has been deprived of. It has been deprived of its very existence. Mr. President, distinguished members of the Court, the genocide is the crime of crimes, and very often this expression is used to signify it's the most serious of all international crimes. Now, we use it here to mean that once genocide is established, there is no need to establish the violation of the other rules and principles. we know that the court has been seized by this issue of genocide. But we have to look at it here as well. Why? Because genocide of the Palestinian people relates to the acquisition of Palestinian territory by force. Because the acquisition of Palestinian territory by force is the legal status of the occupation. The prohibition of genocide is incontrovertibly a jus cogens norm. The crime of genocide is defined by Article 2 of the Convention for the Prevention and Punishment of that crime. I quote, "For the purposes of the present statute, the crime of genocide is understood as being any of the following acts committed with the intention of destroying, in part or in whole, a national, ethnic, racial, or religious group. A. Killing members of the group. 2. Causing deliberate bodily or mental harm to members of the group. Small c. Deliberately inflicting on the group conditions of life calculated to bring about its physical destruction, in whole or in part. And D. Imposing measures intended to prevent births within the group, and small e, forced transfer of children of the group to another group." Now, there is no doubt whatsoever that the Palestinian people is a national group within the meaning of Article 2 of the Convention. How could they not be, since they are a people, and they are thus entitled to the right of self-determination? There is no doubt either that those acts mentioned under paras A, B, C, and D have taken place and are taking place right now. The whole world has borne witness to this and is witness to it right now. The war against Gaza, the fifth since 2007, the systematic violation and massive violation of the fundamental human rights and norms of international humanitarian law, which the court has deemed intransgressible. In this respect, it's worth pointing out that genocide does not suppose the extermination of all members of the protected group. The court considered in its judgment of 26 February 2007 that, I quote you, "Genocidal intent must be to destroy at least a substantial part of the group in question," end of citation. And in this regard, the court found in its order of 26 January 2024 that, I quote, "The Palestinians of the Gaza Strip form a substantial part of the protected group." And in between times, the entire world has been witness of the land, maritime and aerial blockade of Gaza since 2007, the excessive use of force by the Israeli army and its security forces in occupied territories, leading to deaths and casualties amongst Palestinian civilians, including children and women and others. The acts of violence and harassment committed by groups of armed settlers towards civilians and children, destruction of property, homes, religious sites, historical sites, confiscation of land as collective punishment, expulsions, forced displacement of civilians, attempts to forcibly transfer Bedouin communities, detention of thousands of Palestinians, large number of women and children, elected representatives over an excessive period, without charge and without guarantee of due process, including ill treatment and sometimes even torture. There have been closing of certain areas, the placing of hundreds of obstacles to traffic, checkpoints, permit regimes impeding the freedom of movement of people and goods, inter alia medical and humanitarian, which is really important. But it's not enough just to establish this substantive element to prove genocide. The specificity of the crime of genocide resides in intent. Now, intent is always, difficult to prove, but such proof is not impossible. if you can establish the existence of a genocidal policy. That means an option taken collectively or individually by the authorities who have the power to decide and carry out this plan aimed at destroying the Palestinians as a national group. And such a policy exists. This is attested by Israeli legal texts, by the declaration of its politicians at the highest level, and by the systematic, coordinated character of its practices and measures. Let us recall the aggression of 1967, and since then the refusal to withdraw from occupied territories, which shows that Israel has occupied these territories to install themselves there definitively. The de jure annexation of Jerusalem, the de facto annexation of the West Bank by settlements which aim, in the long term, to establish a fait accompli. West Bank is no longer Palestinian. The basic law, my Syrian colleague referred to that. I quote here, Israel as the national state of the Jewish people, and in its first article defines the land of Israel as, I quote, the historic homeland of the Jewish people in which the state of Israel has been created. By thus referring with respect to this land, not to the international legality, but to a fable of identity, which includes all of mandated Palestine and more. The same article provides that the right to exercise national self-determination within the State of Israel is exclusively that of the Jewish people, giving thus a constitutional value to the very negation of the Palestinian people's right to self-determination. Let's also point out Article 7, which provides that the state considers the development of Jewish settlements as a national value and will act to encourage and promote their creation and reinforcement. Let us also recall the guiding principles of the coalition agreement of the current Israeli government, which was sworn in on 29 December 2022. The first of these principles expressly proclaims, I quote, that the Jewish people has an exclusive and unchallengeable right over all the areas, all the zones of the land of Israel, and engages the government to promote and develop settlements in all parts of the land of Israel, in Galilee, in Negev, in the Golan, in Judea, and in Samaria. End of citation. The 11th guiding principle asserts that the government will work to consolidate the status of Jerusalem. Let's also recall Israel's leaders' declarations, and we'll only cite two here just to give you a few examples. The first is that of Israel's Minister of Finance, dated 19 March 2023, last year. There are no Palestinians because there is not a Palestinian people. End of quotation. The second is the declaration of the Israeli Prime Minister. I quote him, I will never compromise on the total control which Israel must maintain over security over all territory west of the River Jordan. All territory west of the River Jordan. End of citation. It is clear from these texts and declarations that Israel considers that all the territory of mandatory Palestine is its own, and that there is no Palestinian people. All of the foregoing shows, Mr. President, distinguished members of the Court, it shows the existence of a systematic policy, namely a clear intention and desire to destroy Palestinians as a national group entitled to self-determination and state independence, and to reduce the survivors to a group of stateless refugees.
Let's turn now to the legal consequences that stem from these violations. They may be classified into two categories: the particular consequence of the serious violations of peremptory norms of general international law on the one hand, and the specific consequences of the violation of the prohibition of genocide on the other. The International Law Commission has ascribed specific consequences to the serious violations of Jos Kogen's norms and has defined what it understood by serious violation is grave. A violation if it denotes on the part of the responsible state a flagrant or systematic breach to the execution of this obligation, end of quote. The violation of Jos Kogen's norms committed by Israel are both flagrant and systematic. Flagrant is used to refer to what is obvious for all to see. Is it not obvious to the eyes of all that Israel occupies the Palestinian territories, that it colonizes this territory, that is annexed Jerusalem, that in the war of aggression that it conducts against Gaza, it ignores and lays claim to the disregard it shows for principles of distinction and proportionality. It has deliberately targeted sites and protected persons. Systematic is used to refer to what is done with method and without failure, of what proceeds from a predetermined order beforehand, and what is deliberate. Is it not apparent from the policies and practices of Israel that there is a predetermined order, a plan hatched whose ultimate goal is to destroy the Palestinians as a people, to reduce them to dust as individuals, and that Israel has never ceased working to fulfill it? The results of the grave violations of peremptory norms of general international law, the following consequences: the responsible state cannot rely on circumstances excluding responsibility. Israel cannot assert neither self-defense, nor force majeure, nor distress, nor a state of necessity to exclude its responsibility, nor is it entitled to turn to countermeasures. As regards the other states, Jos Kogen's norms create erga omnes obligations, in respect of which all states have a legal interest. In particular, all states have a duty to cooperate to end, through lawful means, violations committed by Israel. All states have the duty to recognize as unlawful the situations created by the OPT and to refrain from all acts that might constitute aid or assistance in this regard. All states, and not just the aggrieved states, are entitled to invoke the responsibility of Israel. They can demand that Israel ceases these violations and assurances and guarantees of non-repetition, as well as discharging the obligation of reparation. The violation of the prohibition of genocide carries all the specific consequences of the violations of the Jos Kogen's norms. It also carries specific consequences provided for by the Convention for the Prevention and Punishment of the Crime of Genocide, and the Rome Statute of the ICC for all states that are parties to it. These specific consequences are as follows. Firstly, establishment of universal jurisdiction in this regard. State parties must notably provide for effective criminal sanctions aimed at persons guilty of genocide or any of the other acts incriminated by Article 3 of the 1948 Convention. Next, the right for any party to the 1948 Convention to seize the competent organs of the United Nations organization so that they take the appropriate measures for the prevention and punishment of acts of genocide. Thirdly, the right for any party to the 1948 Convention to seize the court through a unilateral request of any dispute pertaining to the responsibility of Israel in respect of genocide or any one of the other acts set out in Article 3, and that's what the state of South Africa did. Fourthly, the right for any state party or for any state that has accepted the jurisdiction of the ICC in accordance with Article 12, Paragraph 3 of the Rome Statute to seize the court if it has serious reasons to believe that a crime of genocide has been committed in its territory. That's what the state of Palestine did. Lastly, the right for any state party to the Rome Statute to defer to the prosecutor of the ICC the situation in Palestine and to ask him to investigate the situation. And that's what, on 17 November 2023, 5 state parties did: South Africa, Bangladesh, Bolivia, Comoros, and Djibouti. We'll conclude our intervention by setting out the legal consequences that flow for the United Nations Organization of the legal status of occupation as we have determined it. In this regard, we can but paraphrase the consequences highlighted by your court in its opinion 2004. The Organization of the UN, specifically the GA and the UNSC, must examine what further measures might be taken to end the OPT and the serious and persistent violations of general peremptory law that are committed there. Mr. President, members of the court, I thank you for your attention.
I thank the delegation of Tunisia for its statement, which brings us an end to this afternoon's sitting. The court will meet again on Monday, 26 February at 10 a.m. to hear Turkey, Zambia, the League of Arab States, the Organization of Islamic Cooperation, and the African Union. The sitting is adjourned.